Next we have Trevor Cook, who's going to talk about the data exclusivity issues to which Ben already alluded, and he's going to do a deep dive into some of those questions.
Okay, thanks, Artie. Disclosure. I have a lot of disclosure in a way. My old firm and my new firm represent a lot of pharmaceutical companies. I came into this, I'm a patent litigator, but I came into the area of data exclusivity nearly 20 years ago in litigation in the European Union, and was involved in a series of cases which established the metes and bounds of the data exclusivity structure in the European Union, which was then effectively codified by the amendments made in 2004 to the 2001 Community Code on Human Medicinal Products. So these are my own views alone, not those of my old or new firm or of any of their clients. Now, data exclusivity. This is something different from patents. It is something different from trade secrets or commercial confidential information. As an aside, I must admit that coming at this from the point of view of an English lawyer, I find the distinction between trade secrets and commercial confidential information one that is hard to understand or to fathom. It is not one that exists in English law. It is one which may perhaps come to exist in English law in years to come, because the European Commission has recently published a directive on, or proposed a directive on the protection of trade secrets. The motivation for this being that there is no consistency in the approach to treating and protecting trade secrets throughout Europe. And I think when you look at what TRIPS has to say about data exclusivity and trade secrets, in fact, trade secrets are in the missing section 2, because I didn't have room for that on the slide and I was going to talk about data exclusivity. But that is not expressed in terms of trade secrets, it is expressed in terms of what I would understand as commercial confidential information, very much along the lines of the sort of discussion which Ben had. But let's look at data exclusivity. And I think it's very interesting that TRIPS approaches this as something separate and different from the protection of trade secrets and commercial confidential information. Perhaps because there is the involvement of the regulator, and the regulator must always be free to to make a decision in relation to approval or otherwise, or indeed withdrawing approval, which is not in any way limited, even though it is dealing with confidential information. But if you look at this, you'll see numerous references in this text to undisclosed text or other data. The basis for protection by means of data exclusivity or regulatory data protection is the concept that the test data is undisclosed. You'll also see when you look at that sentence or couple of sentences that there is an incredible amount of flexibility in the way in which this is expressed in TRIPS. This is in many ways a reflection of the fact that data exclusivity is a relatively new type of intellectual property right, one that has only grown up almost by accident in recent years, but driven by very real needs from the point of view of the incentive structure within the pharmaceutical industry. So, sorry, going backwards, let's go forwards. So, people sometimes ask, why does one need data exclusivity when you've got patents? Well, patents are very much at risk of challenge for a whole lot of reasons associated with the specifics of patent law: novelty, obviousness, insufficiency, excluded subject matter, and those issues don't necessarily have too much to do with what we are really looking to protect and where the investment really lies in much modern drug discovery. Look at the number of molecules which fail between phase 2 and phase 3. It's very hard from a point of view of patent law to get a patent at a phase 3 stage when you've already got a phase 2 disclosure, effectively. So what one finds about data exclusivity is that it much more directly protects than do patents the investment in the clinical trials which are inherent in having to bring a new regulated product to market. And that is why it is not unique to the pharmaceutical sector. One also finds it in agrochemicals, and one finds it in a number of other regulated sectors in Europe. To look at a few of the specifics, in Europe, the period of protection is 10 or 11 years, depending on whether or not a major new indication is secured during that period. 10 or 11 years after the first marketing authorization in the EU for that active. Now, on the face of matters, that's a shorter term than the patent term of 20 years, plus possible patent term extensions. But when you realize that the patent will often have run from a very much earlier date than the date of the marketing authorization, it provides a very real element of certainty to a pharmaceutical company about the sort of returns, on the period of returns it can get on its investment. And indeed, in Europe, we have seen pharmaceutical companies abandon products because they couldn't get the regulatory data protection on them. And companies in this last year or so, taking great care to ensure that there was regulatory data for protection for their products because of the uncertainties which inevitably surround any sort of patent. In the USA, a shorter period of time, which is linked also with the patent term in a way which doesn't occur in Europe, but a different regime, that's for small molecules, a different regime for biosimilars, 12 years of data exclusivity, and the USA and Europe between them effectively have the longest terms of data exclusivity. Now, talking about transparency, I've flagged up there those parts of Article 39.3 TRIPS which refer to undisclosed data. Now, the problem is, if you mandate the disclosure of data, how do you avoid undermining the incentive regime which is inherent in the data exclusivity structure? Now, you can do it within one jurisdiction alone, and I'll show how one jurisdiction, the EU, seeks to do that. But how can one protect it against other jurisdictions, and in particular the jurisdictions which have a much weaker data exclusivity regime than that which exists in Europe and the United States? The internal EU approach, and this is in relation not to the whole, not in relation to what the EU is now talking about in terms of opening up clinical trial records, albeit anonymized, but actually in relation to a particular regulatory route to approval called that for well-established medicinal use. And the Commission found it, in its notice to applicants, actually essential to spell out that the sort of disclosures it makes as a matter of course, as a matter of transparency, in its EPARs, its European Public Assessment Reports, the synopses of clinical trials, which one gets in those. An EPAR is no more than 50 pages or so, and that will be quite a long one. It must be stressed that assessment reports, and so this is the synopses, which are made publicly accessible by competent authorities for reasons of transparency, cannot be considered And this is a deeming provision sufficient to supply sufficient information to meet the requirements of Annex 1, which is what you require to secure an authorization on this well-established medicinal use route, which is effectively meant for things like aspirin and stuff like that. So even with that limited amount of disclosure, they see scope to undermine and frustrate the regulatory data protection structure, the data exclusivity structure, by publication. So with that, I shall leave the comments to, I shall close my comments. Thank you.